The federal government gave California a deadline: stop enforcing these laws, or we will see you in court. California's top law enforcement officer responded with a 2-page letter that read less like a negotiation and more like a dare. And this morning, less than 24 hours after that letter was sent, the dare was accepted. The United States Department of Justice has filed a lawsuit against the state of California, and the scope of it goes far beyond what most people expected. This is not just another Second Amendment challenge. It is the federal government telling a state that its entire enforcement system is systematically stripping citizens of their constitutional rights, and it is asking a federal judge to shut it down. Here's how fast this unfolded. Roughly a week ago, the Department of Justice sent a letter to California's governor and attorney general, warning them that a lawsuit was coming unless they either admitted that 2 of their handgun laws were unconstitutional and stopped enforcing them, or at a minimum opened negotiations by June 30th. That deadline was yesterday, and the response California chose to send was not a compromise or a conversation starter. It was a flat, unmistakable refusal. 2 pages that made it clear the state sees no constitutional problem with any of it. One side of the letter essentially told Washington that California's gun laws save lives, its crime rates are at historic lows, and it has no intention of changing course. The governor followed up publicly, calling the lawsuit politically motivated and vowing the state would not be intimidated. A spokesperson added that California will continue defending the laws that protect its residents and keep dangerous weapons off its streets. Whatever one thinks of the merits, the posture was clear: come and get us. So this morning, that is exactly what happened. The case is titled United States of America versus the State of California, filed in the United States District Court for the Central District of California, naming both the state and its attorney general, and the laws at the center of it are 2 of the most restrictive handgun regulations anywhere in the country. The California Handgun Roster, formerly known as the Unsafe Handgun Act, and the so-called convertible-pistol ban that took effect today, July 1st, the same day the lawsuit dropped. The Handgun Roster is the first target, and it is worth understanding why it has been one of the most controversial gun laws in America for years. Under the Unsafe Handgun Act, California maintains an approved list of handguns that licensed dealers are legally allowed to sell. If a handgun model is not on the list, it cannot be sold in the state, period. To get on the list, a manufacturer must meet a set of technical requirements, including a chamber-loaded indicator, a magazine disconnect mechanism, and since 2013, micro-stamping, a technology that engraves a microscopic identifying code onto every cartridge the gun fires. Here's the problem. Critics have pointed to for over a decade. Virtually no manufacturer has been able or willing to comply with the micro-stamping requirement, which means the roster has been shrinking steadily rather than growing, as older models fall off and nothing new qualifies. The list quietly gets shorter every year. The result is that Californians can only buy from a dwindling catalog of approved handguns, while the same firearms freely available in the rest of the country are effectively banned inside the state. Not because any court ruled them dangerous or unusual, but because they cannot pass a technical checklist that most of the industry calls unworkable. A federal judge has already weighed in on this in a separate ongoing case brought by private plaintiffs. A district court ruled that California's roster requirements violate the Second Amendment and enjoin the micro-stamping, the chamber-loaded indicator, and the magazine disconnect provisions. The Ninth Circuit put part of that order on hold while the appeal continues, but the DOJ is now using that earlier ruling as part of the foundation for its own broader case. It is essentially building on top of a fight that was already underway and adding the full weight of the federal government behind it. The second law under attack is the one that just took effect today, and it is the reason many people are calling this the single most aggressively timed lawsuit of the year. California passed a law in 2025 that prohibits licensed dealers from selling any semi-automatic pistol with a cruciform trigger bar, that is a component that can be converted into a fully automatic weapon by the installation of a small aftermarket device, sometimes called a switch. That device is already illegal under both federal and state law. But rather than going after the switch, which is already banned, California went after the gun itself, targeting any handgun whose internal design makes it susceptible to the conversion. The law is widely referred to as the convertible-pistol ban. And because the cruciform trigger bar is a defining feature of one particular manufacturer's design, one whose patent has since expired and whose mechanism has been adopted by other makers, The practical effect is to ban the most popular handgun platform in the country from being sold in the state. Before this lawsuit, there was only one other legal challenge to that ban, and it was voluntarily dismissed. So until this morning, nothing was standing between the law and full enforcement. But here is where this lawsuit becomes something fundamentally different from any other gun case in California. The DOJ is not simply arguing that the state passed a couple of unconstitutional laws. It is invoking a federal civil rights statute and accusing California of running what the law calls a pattern or practice of conduct by law enforcement officers that deprives citizens of rights guaranteed by the 2nd and 14th Amendments. That legal theory is enormous, because it turns the case from a dispute about two specific statutes into an indictment of an entire enforcement system. The DOJ is saying that every time a California law enforcement officer enforces these handgun restrictions, that officer is acting as an agent of the state in a systematic violation of a constitutional right. It is the same legal mechanism the federal government has historically used to go after police departments for civil rights abuses, now pointed at gun law enforcement. And the prayer for relief, the section where the government tells the court exactly what it wants, makes the scope unmistakably clear. The DOJ is not just asking a judge to strike down two laws. It is asking for a declaratory judgment that California's enforcement apparatus constitutes a pattern or practice that deprives citizens of their rights. It is asking for a permanent injunction blocking the state and its agents from enforcing both the roster and the convertible pistol ban. And it is asking the court to order California to adopt new policies and procedures to remedy the violation and to build systems that identify and correct unconstitutional enforcement going forward. In other words, the federal government wants a federal judge to supervise how California enforces its gun laws. That is an extraordinary ask, one that goes far beyond simply erasing a statute from the books. The timing of all of this is not lost on anyone watching. This lawsuit landed on the same morning. The convertible pistol ban officially took effect, meaning the federal government is challenging a law on day one of its existence. It comes less than 48 hours after the Supreme Court granted review of the nationwide rifle ban question. That decision will directly affect California's own assault weapons ban through a separate pending case. It comes days after the court struck down Hawaii's carry restrictions and limited marijuana-related gun prosecutions, both of which have downstream effects on California litigation. And it was filed by a section of the DOJ's Civil Rights Division that did not even exist until recently, the Second Amendment section, which was created specifically to bring cases like this one. The head of that section personally signed the filing. California's response so far has been defiant. The governor has framed the suit as a politically motivated attack on laws that save lives. The Attorney General's office has made clear it intends to fight. And on the other side, the federal government's acting attorney general said the Constitution is not a suggestion, and the Second Amendment is not a second-class right. He added that California cannot ban the most popular type of handgun in America. Both sides are dug in, neither is blinking, and a federal judge in the Central District of California now holds the next move. So here's the bottom line. The federal government has sued California over its handgun roster and its newly enacted convertible pistol ban, using a civil rights enforcement theory that goes beyond the laws themselves and targets the state's entire system of enforcing them. The state was given a chance to negotiate and chose to refuse. The lawsuit was filed the morning the ban took effect, and this case now sits alongside a Supreme Court rifle decision, a pending magazine challenge, and a roster case already on appeal. Together, they create a legal collision that could reshape the firearms landscape of the most populous state in the country within the next 12 months. That's it for today, folks. See you in the next video.